Good afternoon. Thank you very much. Please be seated. And please call the case.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled James Needham versus Roxanne O. Smith, Trust 9-1519, Madeline Casson, Trustee, case number 24 AP118. Representing the appellant, Roxanne O. Smith Trust 9-1519, Madeline Casson, Trustee, is attorney Amy Goddard. Appellee James Needham is self-represented.
Okay, thanks very much, Mr. Needham. Welcome. You understand, after counsel has a chance to speak to us, and she'll have 15 minutes, and then you'll have 15 minutes. Typically, the appellant will try to conserve some time to argue in rebuttal, which means that she would have an opportunity to speak again after you finish, but you would not, okay? As the appellee, that's the way it works. So the appellant always has a chance to have the last word, all right? Okay, so having said that, that should not count into anybody's time. Counsel, please come on up. And if you would, go ahead by introducing yourself and identifying your client and then proceed.
Thank you, Your Honor. May it please the court, my name is attorney Amy Goddard. I represent the Roxanne O. Smith Trust in this appeal. Your Honors, this is an appeal from a partition case, but this case is about more than the calculation of contributions and offsets. This case is about assuring that the law secures peace and promotes the enjoyment of property. It's about refusing to reward hostile, violent, and abusive conduct. Now, the facts in this case are heart-wrenching, but they are also not on appeal here today. In 2015, Ms. Smith lived in Lincoln, Vermont with her two young school-age children. She met Mr. Needham, the two began a romantic relationship. And in 2017, they purchased property together, a single family home in Lincoln, Vermont, that is the property that's at issue in this partition case. Not long after purchasing the home together, Ms. Smith, who was in her 30s, was diagnosed with a cancer that would soon take her life. She was, however, also dealing with another dangerous situation, an abusive relationship with Mr. Needham. Now, when it became clear that she could no longer stay in the home safely with her children and Mr. Needham, Smith fled the property to a hay barn where she lived with her two children so that they could remain in district for the school that they were going to have that continuity while she underwent cancer treatment and ultimately passed. Now, when it became clear that she was not going to survive this cancer, she attempted to resolve the joint ownership with Mr. Needham. The parties had taken the property as joint tenants with rights of survivorship. Accordingly, if either of them passed, the property would automatically pass in full to the other party. Now,
So if I can interrupt you.
Certainly.
What is the mandate that you are looking for from us? What would the, if you were successful, what would our order say to you and to Mr. Needham? What would the substance of the order be?
Thank you, Your Honors. So the court in this case found that even though Ms. Smith fled the property due to fear, and that fear was from Mr. Needham's conduct, that didn't constitute ouster, that was not sufficiently open and notorious, I suppose, of an overt act to constitute ouster, such that she would be entitled to the offset from his contributions of the rental value. So an order from this court would unequivocally state that violence, hostile conduct, threats can constitute ouster every bit as much as changing the locks or sending a notice of no trespass.
So you're relying upon, if I understand the briefs right, this Whippy case, is that right? Or these principles?
The Weinkoop versus Strauss case, Your Honor, and essentially.
Weinkoop, okay.
Yes, and our argument is threefold. First, the trial court held that there isn't any law in Vermont that would support ouster under these circumstances, and we disagree. I believe that Weinkoop v. Strauss does in fact support ouster under these exact circumstances. There you had two parties, they were in a romantic relationship, their relationship went south. They sent dueling notices, essentially a notice to vacate and a notice of no trespass. And what ultimately drove the plaintiff from her home was the defendant's hostile conduct. So he was hostile to her guests, and hostile to her contractors. That's what the court found. And it was that hostile conduct that drove her from the home and constitutes ouster.
Doesn't the ouster have to be wrongful?
Yes. Your Honor.
And isn't that what you're talking about here with those facts, is the wrongfulness of it rather than the fact of ouster itself?
Well, I think that those facts establish both. The dueling notices were sent. Neither party vacated. The plaintiff didn't vacate until the conduct from the defendant became so hostile that she feared for her safety. That was essentially the basis of the ouster. And then the fact that the conduct was hostile is what also made it wrongful. So on those facts are analogous, if not much less severe than the facts.
But Weinkoop says it requires some overt and notorious act or acts of an unequivocal character indicating an assertion of ownership of the entire premises to the exclusion of the right of the co-tenant. Isn't that the test for ouster? I agree with Justice Eaton that the language that you're referring to has to do with whether it was wrongful or not. Isn't it kind of a two-step process? You determine whether somebody was excluded as a co-tenant of the property intentionally, and then determine whether that was wrongful.
Yes, Your Honor, I agree that that's.
So does it meet the first part of the test?
Well, I would argue that the same conduct could meet both of those elements. Conduct could be an overt act that asserts ownership over the entire property, and also in and of itself prove the wrongful element. So if you strike someone and place them in fear of being in the property, that is an overt act of saying, if you're at this property, you're in danger. So I'm the one who controls this space.
So if we ruled in your favor, where is the line drawn? A person could say, I felt I needed to leave this house because of X, Y, or Z. You know, you're making a compelling argument about abuse, and I understand that argument, but where does it end from there? Isn't it quite a slippery slope?
Well, it's a question for the trier of fact, certainly, Your Honor. And in this situation.
Well, the trier of fact found there was not sufficient evidence, right?
Well, the trier of fact found that she fled the property due to fear. That was found as fact by the trial court. It's not on appeal. She was afraid of Mr. Needham. There was substantial evidence supporting that finding. The court noted one time when she came back to retrieve her belongings, when Mr. Needham attacked her in the bathroom, even while she had friends and family there to protect her.
So is there some way in which you are attacking the trial court's findings?
No, Your Honor, we're not attacking the trial court's factual findings. We agree with the trial court. She did flee. She was in fear. Mr. Needham's conduct was violent and abusive, and she left to keep herself and her children safe. That is not on appeal at all.
But doesn't that turn this into a subjective test from an objective one?
Well, in any case, when you're finding ouster, you have to determine whether or not the facts where the co-tenant in possession barred entry rise to the level of ouster. I would suggest in a hypothetical situation, if I change the locks but then sent you a key, is that ouster? Did I send it to the right place? Did I, make sure that there was a, certified mail? All of these things would have to be heard at each level. Each case is obviously unique.
But all of those facts that you're giving us are objective facts, rather than your client saying, I was in fear. I left because I was scared.
Sure.
That's a different matter. That turns it into a subjective that doesn't exist on the issue of whether there's been an overt and hostile act.
Well, the court obviously still has to determine whether or not that fear was based in conduct of the co-tenant in possession, such that fear was an ouster. They created a fear that sent them from the property. And in this case, that was already decided by the trial court. That issue of whether or not that subjective fear was reasonable was decided by the trial court. And we actually did not have Ms. Smith, she had passed, to testify to this. So the court was making these determinations based on, the objective observable facts.
So
as
what
they were
was it the
in
trial court disagreed with you here? I've got in my notes that, as you said, that the trial court agreed that Ms. Smith feared Mr. Needham and left possession of the property because of his fears. And then the trial court said, I agree that, or later, I think, said, I agree, but the judge said you had cited no case where the Vermont Supreme Court has recognized ouster under similar circumstances without proof that one party excluded the other, as in Winku. So what do you say about that? Is that the nexus of your arguments here on appeal?
Your Honor, first, we suggest that Wine Coop does support it. Second, we suggest that if there is no law saying, not finding ouster under these similar circumstances, there is certainly no law that says you cannot find ouster under these circumstances. And public policy would promote a finding, in fact, that violence and threats can constitute ouster, and sister jurisdictions have found the same.
What are the threats that the trial court found?
In this specific case, Your
Yeah.
Honor? So, Your Honor, this is a case of domestic violence, right? The most intimate level of violence that many.
Right, but can you be specific for us, not just general?
Sure. So we did not have Ms. Smith there to testify. She sadly passed. So we
Right,
could not speak
right.
directly to the threats that Mr. Needham made toward her during their times when they were.
Well, I've got him, let me give you an example. I've got in my notes that he said, and I don't know if this is contested fact, he said he was going to wait her out.
That's correct.
As far as the implication was, he's going to wait until she dies so that he would take title upon her death as joint tenant. Is that a fact that you rely upon? Is it contested? What is the situation with that?
That's not a contested fact, Your Honor. That came into evidence. There was no objection. There was no evidence from Mr. Needham that he didn't say that.
So is that a fact that you argue is evidence of the fear of that your deceased client was placed in?
Your Honor, I don't think that that's a fact that goes directly to the fear. That statement was made after Ms. Smith had moved out, had vacated, had moved into the hay barn, and then at some point she did obtain a residence. She did rent a single family home. And that statement was made, I believe, when she was already had already separated from Mr. Needham. And so the facts in this case suggest that she was isolated, that she was subjected to, many statements that were abusive in nature, that she suffered unexplained injuries, that she was fearful and trembling when she was around him. And then there was the one instance where he launched himself into the bathroom, pushed her against the sink while she was engaged in chemotherapy and dying of cancer. Because he felt that she had touched some of his belongings in the bathroom.
Ms. Goddard.
Oh, Justice Cohen?
Oh, I'll defer.
Oh, thank you.
Go ahead.
So, Ms. Goddard, I just want to follow up on a question that Justice Carroll asked you, which is, where do we draw the line? Because it is a slippery slope. And oftentimes in a high conflict relationship with an abused spouse, that spouse will seek an RFA. The RFA will be granted, assuming it's granted, the temporary, and then there's a final hearing. Sometimes the court will preclude the abuser from entering the premises or going back to the premises. So is this court going to have to find ouster in all those cases going forward if we adopt your interpretation of Winku?
Well, Your Honor, the court did deal with this to some degree in Whippy. There was an RFA, and the court found that period, there was no ouster for the period of the RFA, that the family court had jurisdiction there and had dealt with the allocation of the property.
And it's a court order.
Yes.
So that's the distinction.
Of the RFA.
But
So
here there was an RFA, at least a temporary one.
that's correct.
And what I remain a little bit confused about is that Mr. Needham, was made to leave the premises. But then did your client leave the premises while he was still
No, Your Honor.
vacated from the premises?
Yeah,
What's the timing of that?
It was difficult to discern that because it was in fact just a temporary.
Yeah,
Did not become a final, and so I did not have access to the records. The court didn't have access to the records there. However, my understanding is that she got the temporary and then declined to pursue it. The parties remained together for some period of time, and then she ultimately vacated when she vacated the hay barn in 2018.
So, Ms. Goddard, you had, in essence, there were two causes of action. One was for partition, which was done. There's no issue involving how the court partitioned and made an equitable distribution of contributions and the
That's
like.
correct.
The second is the claim for ouster. And the element of damages regarding the ouster is rental value? Is that was what was argued?
That's what the trial court found, that it was rental value, that Miss Smith would be entitled to the rental value of the property as an offset to the contributions that Mr. Needham made in her place during that time.
But then made a statement regarding the lack of evidence regarding any type of formula that could be utilized to determine how much that would be.
Yes, Your Honor, and the court took two issues with the evidence that came in on rental value. And the first was that there was a lack of foundation, which I would argue is not a sufficient reason to ignore evidence that has come in. A foundation is an issue of admissibility. That evidence came into the record with no objection. There was evidence from Miss Casson as to what she thought the rental value of the property was as the owner. And there was also evidence of what Miss Smith had to pay to have a single family residence in Lincoln, Vermont, which is an extremely small
Okay.
community.
You see your time is.
I do, Your Honor.
All right, your time has expired. Thank you very much.
Thank you, Your Honor. Appreciate your.
Thank you. We'll hear from Mr. Needham now. Mr. Needham, please come up to the podium. And for the record, if you would, before you start, there you go. Introduce yourself and then go ahead.
My name is James Needham. I'm representing myself in this matter.
Thank you.
So Ms. Goddard, I believe, is misinterpreting the cases she cites. In the Wincoop case, there were in fact overt and notorious acts. The Cardoza case, there was a notorious threatened violence. The quote was, "I'll pop your head off." I never did any of that stuff. I didn't threaten anybody. Furthermore, Ms. Smith sold her interest to a third party trust in writing. There was no addendum regarding ouster. There was no disclosure of a pending legal dispute in that sale. There was no evidence presented at trial that the trust ever attempted to access the property or was ousted. Ms. Goddard would argue that Ms. Casson was in fear of me via her sister's fear. Ms. Casson actually had herself removed as a person from the case. It's only the trust. Trust can't be afraid. There's no sidecar that goes with that property sale that says you can come back for something. Additionally, Ms. Casson failed to ever offer any testimony that the property is even legally rentable in the state of Vermont. I think the bigger issue continues in Ms. Goddard's information she supplied this court. She continually misrepresents the timeline of what happened. Roxanne did apply with counsel for a relief from abuse order. She was granted a temporary relief from abuse order. We did go to Addison County Family Court. Again, I had 48 hours notice, if that. I was escorted from the property by 2 state troopers and a German Shepherd, with the clothes on my back.
And can you help me with the timing?
Yes,
So you left, right?
I left.
And,
I had the weekend to think about it. I was unable.
but was Ms. Smith in the property when you left?
She
In other
was,
words, did she go back in and stay there when you left?
I would assume so.
But you don't know?
I don't know.
Sure.
It was only 2 days. I was served on Saturday. We had a hearing Monday. It was a contested hearing in family court. The family court quickly decided not to grant it because there was in fact no allegation of abuse. There was allegation of an argument and some heated words. You know, so Ms. Goddard continually says Ms. Smith moved into a hay barn. She moved into an apartment in a hay barn on a mountainside estate. Briefly, she then secured a single family home.
How do her sons play into this? Were her sons in your custody at some point?
Never legally, no.
In your care
Absolutely.
while she was out of the house?
Oh, no.
Oh, so when she moved out, they moved out?
Yes,
Okay.
And was the hay barn a finished apartment?
yes,
So it had heat
yes,
and water?
yes. Bathroom, small kitchenette. As far as I know, there's tenants there to this day. You know, so again, Ms. Goddard continually misrepresents the timing. The temporary relief from abuse order that was ultimately denied was in 2017. Roxanne moved back into the property. We attended counseling. It was not successful. You know, she left the property permanently in July of 2018.
When did she die?
2019, or I'm not sure. I can tell you off the top of my head. You know, so to read what Ms. Goddard filed with the court, you know, she left in 2018 and got a relief from abuse order. That's simply not the case.
Did you say that you were going to wait her out? Is that why she put the property into a trust?
No, that was a comment that one of her multiple lawyers said in writing. After she left the property, we had no communication until, except via her attorneys, until she came to retrieve her belongings. So I would suggest that Ms. Goddard has violated the rules of professional conduct.
Well,
she's not been candid.
No. Wait. Mr. Needham, you don't have a claim here. You're here as the appellee. Please don't get up and use this forum to make arguments that impugn the integrity of your opponent. That's not what we're here for. You want to make a claim against Ms. Goddard, a professional conduct claim? There's a whole process to do that. Go downstairs and talk to the clerk about how to do it.
I've
But
been in contact.
that's not for us. Not at this point.
Okay, well, she has misrepresented things in her testimony to you. I've been in contact with Michael Kennedy. He's generally non-responsive. He has asked Ms. Goddard to file amended motions clarifying her statements at the trial court. She failed to ever do that. This court should be very concerned with her.
No,
her demeanor.
again, this is not what we're here for. You want to talk about ouster, talk about the law, respecting ouster, argue your position about that, that's fine. But we're not going to, we're not going to entertain your arguments about unprofessional conduct. There's no complaint that's pending in front of us. Stick to the issues that are here.
Then simply put, the trust was never ousted. They are the tenant in common. They're simply an absentee tenant in common.
But that issue aside, you're also saying she was never the subject of ouster either.
He was not. You know, there has to be an overt or notorious act. Otherwise, it is very subjective, and it's really, you know, it's subverting my rights to due process when it's she was afraid. And that's all I have.
Okay. Thank you very much. Does the appellant have time?
Appellant has 0 time remaining.
All right, please call a conclusion of the hearing.